asked an employee for sex, commented on employees' breasts, tried to engage employees in sexual discussions, and used sexual profanities. Commissioner Lucas, was it your decision to dismiss that case?
Thank you for the question, Senator, and for the opportunity to acknowledge my prior tweet and to note that I was wrong at that time. At the time that I indicated
I'm sorry, you're referring back to the tweet about the agency?
The independence of the agency. And yes, that's directly relevant to your question because the agency is an executive branch agency.
Okay,
but at the time that I indicated that, I was not aware of the long record that the agency had taken that position. And therefore, it's important for, as an executive agency, us to follow the president when he directs us in an executive order to defend women's rights and to refer to...
In the span of a few minutes during a Senate hearing, Senator Patty Murray laid bare one of the most profound constitutional and democratic dilemmas of our time. What happens when an agency designed to protect workers from discrimination is pulled into the vortex of partisan politics? On January 27, President Trump made history, not by signing landmark legislation or appointing a groundbreaking leader, but by firing 2 sitting commissioners of the Equal Employment Opportunity Commission, EEOC. Never before in the EEOC's 60-year history had a president unilaterally dismissed commissioners before their terms expired. The fallout from this action has rippled far beyond the Beltway. For advocates of workplace fairness, it signals a dangerous shift. The EEOC, long seen as an impartial enforcer of civil rights law, is being rebranded as a political instrument of the executive branch. The confrontation between Senator Murray and Commissioner Lucas over sexual harassment cases, gender identity protections, and the Pregnant Workers Fairness Act crystallizes the stakes. At issue is not just the fate of individual cases, but whether Americans can still rely on independent institutions to shield them from abuse and discrimination in the workplace.
Thank you very much, Mr. Chairman. Let me just start by saying that on January 27, President Trump made an unprecedented and illegal move to fire 2 of the EEOC commissioners, Jocelyn Samuels and Charlotte Burrows, without cause. In the EEOC's 60-year history, the president has never fired a commissioner before their term expired. Commissioner Lucas, in 2021, you actually criticized President Biden's move to fire the former general counsel, calling the EEOC a, quote, independent agency. Now that President Trump is in charge, all the talk about the EEOC's independence has disappeared. These illegal firings are yet another example of the very long list of ways President Trump is weaponizing and making independent agencies political. In this case, the one Americans actually rely on for justice when they face discrimination at work. I led a letter to President Trump pressing him to reinstate Commissioner Samuels and Burrows. I urge my colleagues to join me in opposing any nominations to the EEOC until President Trump does that. Now, Commissioner, let me start with you on questions. Under President Trump, the EEOC has moved to dismiss cases they had previously agreed on by a majority vote to litigate. For example, the Commission recently dismissed a case, Lush Cosmetics, where the EEOC itself had alleged that a manager groped an employee, asked an employee for sex, commented on employees' breasts, tried to engage employees in sexual discussions, and used sexual profanities. Commissioner Lucas, was it your decision to dismiss that case?
Thank you for the question, Senator, and for the opportunity to acknowledge my prior tweet and to note that I was wrong at that time. At the time that I indicated
I'm sorry, you're referring back to the tweet about the agency?
The independence of the agency. And yes, that's directly relevant to your question because the agency is an executive branch agency.
Okay,
but at the time that I indicated that, I was not aware of the long record that the agency had taken that position. And therefore, it's important for, as an executive agency, us to follow the president when he directs us in an executive order to defend women's rights and to refer to individuals solely by their biological pronouns and to defend biological
can you
reality.
answer the question on the dismissing the case? You were acting chair of the commission when Lush Cosmetics.
Yes.
Was it your decision to drop the case?
It was my decision, in consultation with our career staff, unanimous decision of the career staff, that it was impossible to both comply with the president's executive order as an executive branch agency and also zealously defend the workers who we had brought the case on behalf. We could not balance both of those interests, and therefore we gave them an opportunity to intervene, and the case proceeds forward with those workers taking the position on their own.
Well, I just want to be clear. What you're saying is that when an employee is groped, propositioned for sex, and called abject slurs at work, the EEOC will do absolutely nothing to enforce anti-discrimination laws if that employee happens to be non-binary or otherwise doesn't conform to this administration's ideas about gender. Is that correct?
Respectfully, I disagree with that conclusion, Senator. What I am saying,
I don't know what conclusion we come to other than that with that decision.
as an executive branch agency, we are complying with the executive orders. Our doors, however, are open to all workers as statutorily required. We accept all charges, regardless of how they are framed or what they are indicated. And I've made clear in repeated statements that anyone can bring a charge. They will be treated professionally, and they will receive
I'll just say this for the committee, and I just have a few seconds left. It shouldn't matter what someone's gender identity is. If they are harassed at work, they should be able to get the justice they are entitled to under the law. I just have a few seconds left. I want to ask you about, in December 2022, Congress passed my Pregnant Workers Fairness Act, which requires employers to provide reasonable accommodations to employees' limitations related to pregnancy, childbirth, or related medical conditions. Most reasonable people would agree that recovering from needed abortion care is a condition that is related to pregnancy. You voted against PFWA's implementing regulations, and you've indicated that you intend to revise those regulations to narrow the situations the law covers. Do you agree that PFWFA covers miscarriage-related accommodations?
Senator, I do agree that it covers miscarriage-related because that would be related to a childbirth. My vote to disagree with the implementing regulations came in as a disappointment to me. I advocated for the PWFA. I think it was an important bipartisan law.
Yes.
But it is important that the Commission act with the scope of authority that Congress gave us, and we are not Congress. That rule, however, strove to displace Congress and to rewrite the rule in ways that exceeded our authority.
Commissioner Lucas, let me just say, and I am out of time, I recognize that, if it's necessary to protect a woman's health or her fertility or a fatal fetal abnormality, the law should cover that. And I find it really concerning that the Commission doesn't agree with that interpretation of the law as we passed. Thank you, Mr. Chairman.
Senator Husted.
The Equal Employment Opportunity Commission was created in 1965 under the Civil Rights Act of 1964. Its mandate is simple yet profound: enforce laws prohibiting workplace discrimination. Over decades, the EEOC has investigated claims of racial discrimination, sexual harassment, gender bias, ageism, and, more recently, discrimination based on sexual orientation and gender identity. Traditionally, the EEOC has been treated as quasi-independent. While technically an executive branch agency, commissioners are appointed for fixed terms that often overlap administrations. This arrangement was designed to prevent wholesale politicization and ensure continuity in civil rights enforcement. The stability of staggered terms has historically protected the EEOC from abrupt swings driven by partisan agendas. By firing 2 commissioners without cause, Trump shattered this convention. The move did not just unsettle bureaucratic norms. It called into question whether the EEOC could still function as a fair referee in disputes between workers and employers. On January 27th, Trump dismissed Commissioners Samuels and Burrows. Both were Democrats, both had years left in their terms, and both had reputations as strong advocates for civil rights. In the EEOC's 60-year history, no president, Republican or Democrat, had ever fired commissioners mid-term. The significance is twofold. Precedent-breaking. Once a president has done this, future presidents may feel emboldened to remove commissioners at will, transforming the EEOC into an arm of the White House rather than an impartial body. Chilling effect. Remaining commissioners may hesitate to enforce the law aggressively if they believe their jobs depend on aligning with presidential directives. Senator Murray framed the action as part of a very long list of ways President Trump is weaponizing independent agencies. Her choice of words is telling. The EEOC is no longer just an agency that enforces civil rights. It is now, in her view, a political weapon wielded to advance ideological goals. Perhaps the most striking moment in the hearing came when Commissioner Lucas acknowledged a past statement, specifically a tweet from 2020, criticizing President Biden's firing of a former EEOC general counsel. At the time, Lucas defended the agency's independence, but under Trump she reversed course, declaring that the EEOC is an executive branch agency that must follow presidential orders. This rhetorical shift is more than political opportunism. It represents the redefinition of the EEOC's very identity. If the EEOC is no longer independent but simply another instrument of executive will, its credibility as a protector of workers' rights collapses. Workers cannot expect impartial enforcement of anti-discrimination laws if the agency prioritizes compliance with presidential directives over justice. The dismissal of the Lush Cosmetics case provides a vivid example of how politicization undermines workplace protections. The allegations were shocking. A manager groped an employee, propositioned workers for sex, made lewd comments about breasts, and hurled sexual profanities. The EEOC itself initially found merit in the complaint and voted to pursue litigation. Yet the case was later dropped. Commissioner Lucas explained that it was impossible to comply with the executive order while also zealously defending workers. The order in question required agencies to adhere to biological pronouns and constrained how gender identity could be recognized in enforcement. In Lucas's view, this made it impossible to balance defending workers with following presidential directives. The outcome? Workers were left to fend for themselves. They could intervene in the case privately, but the EEOC, the very agency created to protect them, walked away. Senator Murray's response was cutting. What you're saying is that when an employee is groped, propositioned for sex, and called abject slurs at work, the EEOC will do absolutely nothing if that employee happens to be non-binary, or otherwise doesn't conform to this administration's ideas about gender. This is not just a hypothetical concern. It is a roadmap for selective enforcement. Workers whose identities align with the administration's worldview may receive protection, while those who fall outside prescribed categories are left unshielded. Senator Murray's response was cutting. What you're saying is that when an employee is groped, propositioned for sex, and called abject slurs at work, the EEOC will do absolutely nothing if that employee happens to be non-binary, or otherwise doesn't conform to this administration's ideas about gender. This is not just a hypothetical concern. It is a roadmap for selective enforcement. Workers whose identities align with the administration's worldview may receive protection, while those who fall outside prescribed categories are left unshielded. The confrontation between Senator Murray and Commissioner Lucas was not just another tense moment in Washington. It was a microcosm of a larger struggle over the future of American governance. Will independent agencies remain bulwarks of fairness and impartiality, or will they become pliant instruments of presidential power? For workers facing harassment, discrimination, or pregnancy-related challenges, the answer could determine whether they find justice or abandonment when they need it most. Trump's unprecedented firings and the EEOC's subsequent actions suggest a dangerous tilt toward politicization. Yet, Murray's relentless questioning shows that Congress is not powerless. The battle for agency independence is also a battle for democracy itself. If America allows the EEOC to become another political weapon, it risks betraying the very workers it was created to protect. The fight over independence is not an abstract constitutional debate. It is a fight for justice in every workplace across the nation.